Hi, everyone. Welcome to our webinar. Just want to make sure everyone can everyone hear me okay? Everything's fine? Yep, perfect. Um, my name is Roosevelt. I'm a principal lawyer at No Borders Law Group. And today's topic, it's what you need to know about bringing your partner or child to Australia. Right? So yeah, next slide. We'll move it here. Who are we? So we are experts in Australian visa laws. NB Migration Law is a dedicated team of registered migration agents and lawyers. Our international team has a wealth of professional and personal experience, and it can assist you with smooth transition to a new life in Australia. So the picture that you see there is from a director and founder, which is also a principal lawyer of the entire group. No Borders has been serving clients for 27 years. Agnes there came to Australia in 1987 and established a new life, in a familiar country. So she can relate to a lot of the things that we're going to discuss here and the challenges that we all face moving to a different country. So she began practicing migration as a migration agent and established what is now known as No Borders Migration Law Group in Queensland, New South Wales, Victoria, and Adelaide. So what we do, we offer a range of services to cover from complex requirements within the migration landscape, from family visas to employed sponsor visas, and anything in between. Okay, now change to the next slide. So that's just a org chart of our group. We have been around since 1998, but the No Borders Law Group, as we know today, was formed in 2022. So we have a commercial law division, employment law division, migration law, and property law. I'm part of the migration law division, and here at the Sydney office. Okay, so enough of us. This is so our agenda today, it's partner visa pathways based on your residency status, what defines a genuine relationship, how to prepare strong and supporting evidence, temporary visa holders and subsequent entrant options, child visa eligibility and common issues, and what happens after you apply. Partner visa options based on your status. So if you are an Australian citizen or an Australian permanent resident or eligible New Zealand citizen, you may sponsor your partner through onshore partner visa, an offshore, or a prospective marriage. These days, it's becoming rare and rarer to come across eligible New Zealand citizens. But it is part of our assessment as well to check whether you are one of them. Most people who think they're eligible New Zealand citizens, they in fact they're not. So they might be eligible for, the partners might be eligible for a different visa. So that's why it's important to check your eligibility as a sponsor as well as an applicant. It's a common issue that people tend to focus on the visa applicant only and forget about the requirements to be a sponsor. The sponsor is what we call the partner, the Australian partner or permanent resident partner or eligible New Zealand citizen partner in the application. So, when it comes to the partner visa application, you have two options. Like I said, you have the onshore, which is the 820 and 801, the 309, the offshore partner visa, which is the 309 100, and the prospective marriage visa 300. It is it is 820/801 and 309/100, because when you apply for the temporary visa, which is in that case is the 820 or the 309, you're also applying for a permanent visa at the same time. But that permanent visa eligibility will only come after 2 years, right? Okay, so we go to the next slide. Yeah, so discussing what I said before. So the subclass 820 and 801 onshore partner visa allows you to stay in Australia while the permanent stage is processed. The subclass 801 is the permanent visa, granted usually 2 years after the 820 is lodged if the relationship is still going. Key features are you must be on shore at the time of application. It provides you the bridge visa, so you can stay lawfully while waiting for the outcome of the visa. You can work, study on that bridge visa. Children can be included or added later. You also get Medicare rights while the application is pending. Offshore, it's basically the same criteria, but it's just you applying from outside Australia. So you have the 309 and lets you enter and live in Australia. The 100, which is the permanent visa, and it's granted typically 2 years after the 309. You must be offshore when lodging the application. There's been a change in terms of the approval. Before you had to be outside Australia to receive this visa, but since the recent change in the legislation, you can receive the 309 YY in Australia, right? And that goes for the onshore as well. You can be outside Australia to receive it. It's just the time of lodging that you need to be outside. Children can be included, and there is a specific visa for it, visa subclass for it. The 300 is the prospective marriage visa, also known as the fiancé visa. It's a temporary visa valid for 9 to 15 months. You must marry your sponsor, which is the Australian partner, during that period. After marriage, you can apply for an onshore for the 820 partner visa. You must be offshore when the visa, when applying, when the visa is granted, allows entry to Australia to get married. You need to apply for a partner visa after marriage. What visa you should choose, that would depend on your circumstances. There is no one size fits all situation. So that's why it's important for you to have an assessment first and talk to a consultant and see what's the most suitable pathway for you. Okay. So what defines a genuine relationship? The department defines a genuine continued relationship through evidence across 4 areas. It's also called as the 4 pillars of the partner visa. So you have the financial aspects. So it can be shared bank accounts, utility bills, insurance, purchases. And again, this is not a restricted list, it's just examples. Household, the living together or explain separation, joint leases, mail to same address. Social aspects, photos together, invitations, joint travel, declaration by friends, commitment, joint plans, communication history, joint decisions, statutory declarations. So it's when with our clients, we aim to cover all these 4 pillars when we're lodging their visa applications. So our document checklists are tailored to meet all these requirements here. And there are some misconceptions about documentations and requirements, and you have to provide these documents in order to get, and that's not actually true. So when we assist our clients on document checklist, we provide options as to what they can be accepted by the department. And there is one thing that said there, which is also a misconception that separation necessarily makes the partner visa application impossible to lodge, which is not true, you know. So as long as things are properly explained and the separation makes sense, um, um, uh, it should be okay, right? Just go to the next slide. So bringing family as subsequent entrants and common temporary and skilled visa options. Now, you can bring your family to Australia not only if you are an Australian citizen trying to bring your partner here or children. You can also bring your family if you hold a temporary visa, right? So the temporary, there is a list of temporary visas there, including there some permanent visas too. But the 482 is the sponsorship visa. Um, and once you hold that visa, you are allowed to bring your family, being your partner, de facto partner, your spouse, or children. The 500, same situation. Um, but with the 500, there's some specific requirements that you need to check before coming on that visa. Um, um, so that's why it's important to have a strategy from the beginning, so you don't shoot yourself in the foot later on, you know. So yeah, 491s as well. You are allowed to bring um, your immediate family to Australia, being your partner, spouse, and children. Um, they need to live in a designated regional area, as the 491 holder must also live there. Um, the the 189, the 189, you can apply separately while the application is pending. Um, Once you become a permanent resident, then your option is the partner visa. The temporary graduate visa as well, like it's a graduate visa for 2 years, 2 to 4, depending on the situation. You can also bring your family on that, in the very much similar way that with the 42s, for instance. Training visa, same situation. So yeah, spouse, de facto, children. One of the common questions we receive sometimes is like, can I bring my parents? Can I bring my siblings? No, no, it's like just immediate family, and that being spouse, partners, and children. How to prepare strong supporting evidence. So strong evidence is essential for both onshore and offshore applications. So relationship timeline, joint bills, lease, event photos, um, joint financial accounts, so shared obligations, personal declarations in Form 888s from family and friends, screenshots of messages, emails, and call logs, joint invitations, memberships, and travel booking. So evidence should cover the relationship over time, not just a snapshot. So it's important to give the department overview of the relationship, and trying to balance out your application, right? And that's what we do here. So our document checklists aim to do that, to have a balance overview, to balance the evidence that we are submitting, so we can meet all those 4 pillars that we discussed in the beginning of the presentation. Because when we see applications lodged normally by clients themselves, when they come to see and they can review applications lodged, non lodged by us, then you can see sometimes they focus on one area and completely forget about all the areas, and that can be very risky to the application. Child visas, right? Um, so that's the situation where you have migrated before your children, um, and you want to bring them to Australia. Um, so there are a few options there. You can apply at the same. You can include your children at the same time that you apply for a visa, or you can bring them later, depending on the situation. Again, it's about strategy, what suits you and what doesn't suit you. So we um, so key visa pathways, including all partner visas, depending on situation and eligibility. Like I said, so separate child visas, you got subclass 101, child visa offshore, the subclass 802, child visa onshore, and essentially the requirements are the same. You need to be um, your parent needs to be an Australian permanent resident. And then the subclass 445, which is specifically related to H20 visas or 309s, where you haven't been granted permanent residency yet, right? Yeah, there's a difference there. So a comparison table. So we got the visa type, the subclass 101. It's permanent. It's offshore. Sponsoring parent must be Australian citizen, PR, or eligible New citizen. Child joins family in Australia. No further application is needed. The 802 is the same thing, but with the fact that you're applying in Australia. And the 445, yeah, you must hold the 309 or 820. And you come here to join, the child come here to join their parents. In relation to age, under 18 years of age, age between 18 and 23, depending on financially dependent on the parent and not married or in a de facto relationship. That's very important for that age bracket there. So more that again, that's why I need to get advice before applying for those visas, because the last thing you wanna have you just missing out on an opportunity to become a PR because a requirement for you to be studying or something it's not met. So relationship, you got you can be biological, adopted is a very it's a challenging area, where because it needs to be legally recognized, not only here but overseas, and it's quite tricky. um, um, and custody and consent. If another parent has legal custody rights, written consent or court orders must be provided. So again, that's why strategy is important, and setting up your strategy from the beginning will save a lot of time. Common mistakes to avoid, which is failing to declare the child in the main application. Yeah, it happens, believe it or not. Assuming a child can be added later without meeting subclass rules, correct. Missing health or character documents, yeah. Not securing written permission from non-migrating parents, yes. Unfortunately, it does happen. You start an application and everything's fine, and then your ex-partner down the track doesn't want to consent with the visa, so it's tricky. So it's important to have that information from the beginning, and the rules set so you can get the visa without any complications. Using the wrong subclass for timing and location, yeah, offshore and offshore, 100%. Some people that might think that you can get bringy visas on certain visas, and are allowed to stay in Australia if they apply for it, and in fact you can't. So Yeah, and unfortunately, that's common mistakes that we see here when people come to talk to us. After you apply, what happens next? So bring your visas for onshore applicants. So generally speaking, onshore applicants for a 4H2 visa are usually granted a Bring Visa A, allowing them to remain lawfully in Australia during processing. If a travel is required, the BVB must be obtained. Bridge visas do not apply to offshore applicants. Generally speaking, bridge visas do not apply to offshore applicants. Um, so that's what I said before. You may apply for a visa thinking that you're going to get a bridge visa, and in fact, you're not eligible for it, and that can create all sort of troubles because once the application is lodged, you can now go back and change the visa subclass. Yeah. Estimating processing times, 309 or 870, 6 to 18 months. Permanent partner visas, and again, processing times, it depends on the department. Our aim here is to submit decision-ready applications to reduce processing times. So when the case officer gets to your application, they can make a decision. Permanent partner visas can be granted 2 years after the temporary visa if the relationship continues. Child visa, typically 6 to 12 months, depending on the case complexity and if they're decision ready. If the relationship breaks down, the department must be notified immediately. Your visa must be affected unless you meet certain exemptions. Then family violence, children of the relationship, etc. Legal advice is strongly recommended in such cases. Unfortunately, there's been an increase in reports on domestic violence claims. We have clients in that space, so it's important that if you are under that situation, then you can seek assistance from the appropriate channels. So it's and unfortunately it's an ongoing problem that we see more often and often every year. But travel considerations: offshore applicants must remain offshore until the temporary visa is granted, unless granted a visitor visa. Correct. Onshore applicants cannot leave the country without bringing visa B. Yep, that's very true. Last thing you want to happen to you is on a bridge visa A and you leave the country and you have to wait for the outcome outside Australia. Leaving Australia without the correct visa may result in application withdrawal delays. To the next slide. What you should be mindful of. Every family situation is different. So what worked for someone else may not apply to you. Yeah, that's important for you to strategize your visa pathway. That one size fits all situation. It's not real. So every case is different. So you need to think what's more suitable for you. Evidence matters. So strong, consistent documentation is the foundation of any successful application. Yeah. Time is crucial. Missing a window to include dependents can lead to expensive delays or reapplications. Yeah, and can be financially costly. Your relationship may be questioned. Even genuine couples must meet the department's strict criteria. I often say this, I've been married for 15 years. Yep. With 2 children, and I don't have a joint bank account with my wife. So um, it's does that make my relationship less genuine, or is that vital for my application? So that's what I'm trying to say is that the criteria of the department came up. It needs to be met. They need to have an assessment somehow, and that doesn't make your relationship less genuine in the real world, you know. So small errors can have big consequences. So incorrect visa subclass, poor formatting, missing documents can result in refusal. Yeah, 100%. So one thing that we see quite common is that couples often get mistaken about the dates that they met, the dates that they commit to the relationship and started the relationship. So it is part of our services here to be to cross-check their information, make sure things is consistent. The information is consistent. So yeah, you need to be really careful with those dates because that can lead to questioning and then can lead to complications in the future. Visa application fees increase usually every 1st of July. I think moving forward, that's going to be a trend and that's going to happen every year. That is particularly important in the context of partner visas where the department fees is around $9,000. So it's yeah, like 1, 2%, 3%, then can make a lot of difference in terms of course, if you can avoid that, great, you know, that's better. All right. We coming to the end of the presentation. We're going to a Q&A session now. Does anyone have any questions? All right. Seems that everything was very clear. Um, move on. Can other people support the mature children to come? Um, Look, yeah, those specific questions, like we offer free assessment. I'm going to talk about that on my next slide. That we can discuss specifically about your case. Um, um, so you're welcome to book one. I'm gonna pass and leave a QR code there. Um, and then you can book a time to speak to one of our consultants. I can answer the last question there. There is no restrictions in terms of the country that you're applying from or the country that you hold the passport. Um, um, Generally speaking, um, the department does not profile differentiate, um, but uh, a specific case that you may not allow to apply for certain visas. Um, but I don't think that's the case that you're referring there, Jamie. But like I said before, if we offer free assessments, and you may want to book one of them and discuss that with one of our consultants. Um okay, so um, family migration is more than paperwork. So it's personal. So navigating Australian immigration law for families involve understanding subclass nuances, proving genuine relationships, and ensuring time is right for each applicant. So for more in-depth questions, you can book a complimentary consultation with one of our senior lawyers. So that's the QR code. This is going to take you to our website, and then you just can follow the prompt and book a free assessment. Um, so yeah, again, and that goes to every visa subclass or any migration matter you have. Strategy is everything. So understanding all the particulars of the case and setting up the correct strategy from the beginning, it's vital. You can there are I've worked in several cases where we actually ended up saving money and time for clients just because we understood all the situations there, and then they thought they would be eligible for a certain visa, and in fact they were not. They had to do certain steps before, or they could even skip process and go directly to citizenship, so it's all about understanding your choices there, and that's what we do with the that's what we offer in our free consultation, so we can and and assisting your clients after that. Okay. So, right. So, thank you, everyone. That's our telephone number there if you want to book a time and also email us. Um, but yeah, for today, I hope everyone enjoyed the webinar, and the biggest takeaway is just it is about strategy and understanding your options, and making the right decisions from the beginning. Okay, all right. I'll wish everyone a wonderful afternoon, and see you next time.